Welcome dear students, I welcome you to the course on gender justice and workplace security. In the previous lecture, we discussed the international developments towards women's rights and issues of violence against women. In the backdrop of these international developments, it is imperative for us to know the Indian laws and the Indian legal development and judicial perspectives with regard to gender justice. We start with the Constitution of India. With the independence of the country adopted, enacted and gave to themselves the Constitution. The Constitution, as we say, is the supreme law of the land. It is the basic document which has a special sanctity in that it sets the framework and principal functions of the government and declares the principles governing their operation. The Constitution not only grants equality of sexes, but also empowers the state to take protective and discriminatory measures for the redressal of the cumulative disadvantages on account of the stranglehold of patriarchal society and the existing traditions, myths and beliefs. The Constitution starts with the preamble. The preamble which reflects the ideals and aspirations of the people of the country. It starts with the words, "We, the people of India," and then it goes on to establish the various ideals and values for which it stands. Now, if we see the words "we the people of India," the source can be traced to all the people of the country, irrespective of caste, community, religion, sex, etc. So, therefore, it is the men and women of the nation who have given to themselves the Constitution, the supreme law of the land. The ideals or values which have been identified in the preamble have been enumerated as justice, liberty and equality. So, it would be the endeavor of the state to ensure that each of these values or ideals are realized in the process of the working of the government. So, that is the basic start of the Constitution, whereby it tries to realize certain goals and it makes all men and women a partner in the process to whom such justice, liberty, equality are to be ensured and the consequent responsibility of the state towards that regard. Part 3 of the Constitution speaks of fundamental rights. Now, these fundamental rights are guaranteed to the citizens and in some cases non-citizens as well of the country, and they are what we call as basic rights or human rights, which are the entitlement of every person, every man, woman or child being human beings, and it is integral to their existence and to their living. The important feature of these fundamental rights are that they are enforceable in the courts of law. So, in a sense, if there are any violations of these fundamental rights, any person can move to the courts for enforcement of those rights, and it is the responsibility of the state to maintain and ensure these fundamental rights. In this reference, there has been a case which has been referred of Valsamma Paul versus Cochin University 1996, where the Supreme Court held that the human rights are derived from the dignity. In this reference, we have the case of Valsamma Paul versus Cochin University 1996, where the Supreme Court held that human rights are derived from the dignity and worth inherent in human beings. The human rights of the girl child are inalienable, integral and indivisible part of universal human rights. The full development of personality and fundamental freedoms of women and their equal participation in political, social, economic and cultural life are concomitants for national development, social and family stability and growth culturally, socially and economically. If one sees this observation, one definitely finds reflections of the international developments and international instruments where the human rights of women have been held to be a part of universal human rights, and the fundamental rights tries to uphold these human rights and to see that these human rights are not violated at any level. Now, these are some of the basic rights which are there. There are others that we are coming to later. To start with Article 14. Article 14 lays down equality before law and equal protection of the laws. It lays down that the state shall not deny to any person equality of law and equal protection of the laws. Now, there are two concepts that we can see in this regard. One is equality before law and the other is equal protection of laws. The first is an expression which is found in all written constitutions the world over. It is a sort of a negative concept implying the absence of any special privilege in favor of individuals. The other, equal protection of laws, is a more of a positive concept which implies the equality of treatment in equal circumstances. What Article 14 stands for, it does not speak of any absolute equality. It does not mean that all laws must be general in character or that the same law should apply to all persons. It means that among equals, the law should be equal and should be equally administered, and like should be treated alike. So, therefore, if we are speaking of two groups of people and they are at the same level, then the law should apply equally to them. But if they are unequals, then it cannot be, the concept of equality cannot be emphasized, because they basically stand at a situation where the two groups are not equal to each other. So, therefore, what Article 14 allows is reasonable classification. Classification based on real and substantial distinction, bearing a just and reasonable object sought to be achieved. So, therefore, to start with, Article 14 guarantees the right to equality to all persons. However, such equality is subject to the condition that equals must be treated equally, and in situations where permissible, there can be a reasonable classification which is allowed. In that regard, Article 15 of the Indian Constitution lays down that the state shall not discriminate against any citizen on grounds of religion, race, caste, sex, place of birth or any of them. So, therefore, Article 15 further emphasizes that there should not be any form of discrimination against citizens, and the grounds of discrimination cannot be religion, race, caste, sex being one amongst them. So, the fact that a man and a woman, there cannot be any discrimination only on that basis of men and women. However, Article 15(3) of the Indian Constitution allows positive discrimination in favor of women. Now, it says nothing in this article shall prevent the state from making any special provisions for women and children. So, therefore, it allows for a positive discrimination. That is the significance here, in a sense that this is not violative of what has been stated in Article 14. What it stands for is equals must be treated equally. But if it is seen in a certain situation that two people are not placed equally, given the historical, the political, the social, the cultural and other conditions put together, then in such a situation it would be proper for the state to allow for positive discrimination, such positive discrimination which tends to ameliorate the conditions which are existing for that group of people, and therefore, special provisions for women and children are permissible in the Indian Constitution. Article 16 further speaks of equality of opportunity for all relating to employment. Thus, these are some of the articles which ensure equality and prohibit gender discrimination, except for positive discrimination in favor of women. So, as we said, Article 14 does not indicate that laws must be general in character or application, or the same laws should apply to all persons. It does not stand for that, but it allows for a reasonable classification. Such reasonable classification which must be based on a intelligible differentia and has a rational relation to the object sought to be achieved. However, that classification cannot be arbitrary, artificial or evasive in nature. So, if a classification is made, just for example, or one which is a popular example, on the color of hair, that would be taken more of a arbitrary classification. People with black hair and people with brown hair, that cannot be the basis of a classification. However, if the classification is based on sound reasons and there is an object sought to be achieved by way of the classification, that is permissible within the contours of equality as laid down under the Indian constitutional framework. Now, there have been a plethora of cases or judicial decisions which have gone on to emphasize or establish this aspect of equality, and in many situations, whether relating to employment as well as others, where it has been seen that there has been discriminatory practices or policies which are discriminatory or unfavorable for women, the courts have intervened and courts have set aside such provisions being bad in law or being violative of the constitutional dictum. C.B. Muthamma versus Union of India 1979 is a very famous case where the lady was denied promotion, or she was even discouraged from joining the foreign service and had to give an undertaking that if she married, she would resign from service. If you can recollect the international instruments, that one cannot be discriminated against on ground of the marital status, that she is married or she is unmarried cannot be a ground whereby a woman is denied something. So, here was a condition in the Indian Foreign Service which required that she cannot marry, and if she marries she has to resign from the service, and even the policies were somewhere discouraging of women to join the service. So, that was challenged in a court of law and it was set aside as being bad. Air India versus Nargish Mirza 1981, An air hostess challenged the Air India regulations, which required her to retire at the age of 35 years or pregnancy in case of marriage, whichever occurred earlier. So, here was also a situation where the laws or where the existing service regulations unfavorably discriminated so far as a woman was concerned. So, where in case of a man, such marriage of a man etc., did not have any impact with regard to his continuance in employment, but where it related to a woman and the woman was in the position of a air hostess, it required her to resign from service at the age of 35 years or in case of a pregnancy. So, these were set aside by the court as being bad in law, because such discriminatory policies, regulations cannot be allowed to continue, because it goes against the basic concept of gender justice or equality of the genders for which the state stands for. Charu Khurana versus Union of India 2014 is one of the recent cases which have been there, and this lady Charu Khurana, she wanted to have a card from the Federation of Western India Cine Employees Association as a makeup artist. These are certain sort of associations or unions which exist and which give the necessary permission for a person to register and continue a job, whether as a hairstylist or as a makeup artist. Now, she was for a long time making an endeavor to get a card as a makeup artist, a hairstylist. However, it was reported that she cannot be given the job of a makeup artist, because till then, this is quite a recent case, till then male members are only allowed that job. So, even in 2010 we have a situation where there existed or still exists policies in place which are discriminatory of women. So, therefore, this issue was challenged by the lady in the court of law, that how is it possible that in certain jobs such as a makeup artist, it is only the males who are allowed to take up that job and not women. And one of the propositions which were given by the federation was that traditionally these roles of makeup artists have only been done by men, and if women were allowed, then these jobs will naturally go as more and more women will like to take up the profession, and it will deprive them of their livelihood. However, such argument was set aside by, was completely rejected by the Supreme Court of the country, and it said that it is really sad that even after maybe 60 or more years of independence and the constitution being in place, we are still having policies, still having regulations and rules which discriminate against women and restrict her in terms of the job opportunities that she is entitled to, and necessary directions was given to the federation to give her a card and to see that necessary amendments are made whereby there are no differentiations or distinctions made with regard to the sex of a person or the gender who can take up that particular service. There is section 497 Indian Penal Code, which basically speaks of the offence of adultery. Now, the section as it is there, it allows a man to bring an action for an adulterous relationship against the other man with whom the wife is in such adulterous relationship. However, it does not give any consequent right to a woman whose husband has an adulterous relationship with another woman to bring an action against that woman. Now, this was a case which was challenged in Saumitri Vishnu versus Union of India 1985, where the section 497 Indian Penal Code was challenged on the ground that it violates the right to equality established under Article 14 of the Indian Constitution. Now, in this situation, however, the arguments of the court were different, because there was a definite purpose for which the section in the way that it exists came into being, and in the entire scheme of section 497, woman is seen as the victim, and it is to protect the cause of women that the section has not permitted the woman to bring a case against another woman with whom her husband has an adulterous relationship. So, therefore, the courts upheld the section and said that there is a definite purpose for which it has been made, and therefore, it is not violative of Article 14 of the Indian Constitution. Similarly, reservation of seats for women to the extent of 30% in state services, which was made by the Andhra Pradesh government, was held to be valid. Similarly, it was held that the state can also establish educational institutions only for women, because that would qualify within Article 15(3), where the state is entitled to take effective steps to ensure that the women and children, or there is a promotion of the interests and cause of women and children, and the generations of abuse, generations of denial of rights which have taken place can be somewhere undone by the way of positive discrimination, or allowing for certain opportunities which are specifically for women and not for men and women in general. So, therefore, these judicial decisions have gone on to re-emphasize and establish the concept of equality, and in several cases it has also established that the state is completely free to take appropriate steps for furthering the cause of women, and towards that end they can make special laws, special policies, or even go for reservation of seats for women wherever they feel it is necessary. Next, coming to the right to freedom. Freedom and liberty is very important to live in a civilized society. In that respect, Article 19 of the Indian Constitution lays down 6 freedoms. Now, they are freedom of speech and expression, freedom of assembly, freedom to form associations, freedom of movement, freedom to reside and settle, freedom of profession, occupation, trade or business. So, every person living in India cannot be denied the freedom of speech, to speak or to express oneself in whatever manner one wants to assemble peaceably and without arms, to form associations with regard to mobility of a person as to where a person wants to go, wants to reside and settle, as well as the profession or occupation that a person wants to take up. However, these freedoms are not unrestricted, they are subject to reasonable restrictions. Such restrictions as are laid down in Article 19(2) of the Indian Constitution. So, therefore, when we speak of these freedoms, it necessarily implies in the context of gender justice that every woman has a right to speech and expression, has a right to assembly, to form associations, to reside and settle anywhere, and to pursue any profession or occupation of his choice, and there cannot be any unreasonable restriction on the ground that she is a woman which can be placed on any of these freedoms.